It is seared in my memory because it was not only difficult legally, but factually compelling and very distressing. It's undeniably the case that it lives with me.
Do you have any view as to who was the more culpable between Fred and Rose West?
If anything, I think they potentiated each other. I have never been concerned that she wasn't fully involved. I am a great believer in jury trials and have indeed spent 50 odd years arguing in front of and trying cases with juries. I believe that the public recognise and accept jury verdicts even though there aren't reasoned decisions. But we can't carry on as we are.
You are listening to Inside the Case, brought to you by the University of Law. In 1994, police began excavating the garden of a seemingly ordinary house in Gloucester. The discoveries at 25 Cromwell Street uncovered one of the most horrific murder scenes in British criminal history. A married couple, Fred and Rose West, had sexually assaulted, tortured and murdered at least 12 young women and girls over 2 decades. After Fred West took his own life before standing trial, it fell to the criminal justice system to prove that his wife, Rose, was not a bystander, but an active and willing participant in 10 of those murders. In the highly publicised trial over 7 weeks, the prosecution case was led by Brian Leveson QC. Rose West was convicted in 1995 of 10 murders and is serving a whole life sentence imposed by the judge, Mr. Justice Mantell, who described the crimes as appalling and depraved. Sir Brian went on to become one of the most prominent and influential legal figures of his generation. Sir Brian Leveson studied law at Merton College, Oxford. He was called to the bar in 1970 and developed a formidable practice, mainly in criminal law, becoming a QC at the age of only 37. He was appointed a High Court judge in 2000 and was promoted in 2006 to the Court of Appeal. In 2013, he became President of the Queen's Bench Division and Head of Criminal Justice. Beyond the courtroom, he is perhaps best known for chairing the 2011 public inquiry into the culture, practices and ethics of the British press, known universally as the Leveson Inquiry. He was appointed by the Lord Chancellor at the end of 2024 to carry out an independent inquiry into the crisis of backlogs in the Crown Courts. His report includes controversial proposals to restrict trial by jury. I began by asking Sir Brian, more than 30 years on, what impact the harrowing trial of the Cromwell Street murders had on him.
I remember a very great deal about the case. It is seared in my memory because it was not only difficult legally, but factually compelling and very distressing. So the story, in short, was that between the early 1970s and the late 1970s, Rosemary West was involved in killing 10 girls, one of them being her daughter and the other being the daughter of Fred. And the girls who were killed had simply gone missing. At that time, as a prosecutor, I took the view that it was important to meet the parents of victims of homicide, obviously when they'd finished evidence, so there was no risk there, although now I think that they can meet them earlier. And I met, certainly half a dozen, if not slightly more, of the family members of the victims. And these girls had gone missing in circumstances which their families never understood. And many of them hoped that whatever had caused them to part company from their families had allowed them to live successful, happy lives. And then they discovered, in cases 20 years later, that what had happened was worse than their very worst nightmares.
So was it the meeting with the families and getting to know the human stories behind this case that really made an impact on you?
Oh, not just that. Also the fact that the case was watched by 200 representatives of the press from many, many different countries. As you know from your own experience, in big cases there is sometimes a court artist who doesn't draw in court but then goes out of court to draw and provides pictures for television stations. There were 5 court artists at that trial every day. I recently made a program which was, or was involved in a program which concerned effectively what had happened to the families of the victims. And I was rather struck by seeing a photograph of me walking into court in 1995, immediately after which there was a photograph of me then talking about the case, and this rather old man was to be compared with the young fellow that was walking into court. So it was the nature of the case, the horrific abuse that the case undeniably involved,
which must have stayed with you.
There is no question. So,
and I think you said, haven't you, that you remember this case perhaps more than any other, and you've prosecuted many.
There is no doubt about it at all. There are a number of cases that absolutely stick out in my mind. This is one of them. To such extent that I can actually now still remember, the names of all the victims of Fred and Rose West.
So all these years later,
I haven't forgotten
it.
And I can still vividly remember large amounts of the detail of the case.
Well, we can come to the court case and what you remember from that. Can I just ask you first, though, how you got the brief? Because this must have been a career-defining moment.
Well, so the case was originally due to be prosecuted by a silk Neil Butterfield. And Neil Butterfield was the leader of the Western Circuit, and the tradition was that cases were prosecuted on their own circuits by a circuit member of that circuit.
Yes.
And Neil prosecuted the committal, but he was then appointed to the High Court bench, and they needed another prosecutor. The other really substantial criminal prosecutor on the Western Circuit, I think, had been retained to defend Fred. So he couldn't do it, even though Fred was no longer alive.
Perhaps we should just explain at this point, you came along after
the committal.
Yes, and originally, of course, Fred and Rosemary West were both to be prosecuted.
What happened was, on the 1st of January 1995, Fred West committed suicide. He hanged himself in Winson Green Prison. And that left Rosemary on her own.
You were not involved at this point?
I was not involved in the case. And the committal, which was, I think, in March, was conducted by Neil Butterfield. But after the committal, he went on the High Court bench. Although normally, as I've said, prosecutors come from the circuit where they practice, the other substantial circuit silk had been involved in the case. In any event, the Director of Public Prosecution decided that there should be a number put together from anywhere in the country to prosecute it, and somebody chose me. I can't say precisely why they came to me, but it was a case which I could hardly refuse.
Absolutely.
But I sought permission from the leader of the Western Circuit to do it, which he granted me.
Because you were on the Northern Circuit.
Correct. I was actually then practicing in London, but I'd moved to London a couple of years before, and my practice had been in Liverpool and Manchester.
So perhaps let's just talk a little bit about your early life. Did you grow up in Liverpool?
I grew up in Liverpool. I was educated in Liverpool.
Where did you go to school?
I went to a school which is now an academy called the Liverpool College. And I went from there to Merton College, Oxford, where I read law.
And why did you decide to do law? Had you got lawyers in the family? Or?
No, absolutely not. My father was a doctor, and my mother was actually rather keen that I did medicine, and so encouraged me to do science for A-level, as opposed to what I might otherwise have chosen, on the basis I could still change my mind and do medicine. So I did maths, physics, and chemistry for A-level, but applied to Oxford to read law because I did not change my mind.
What was it that appealed to you about law?
You may remember Boyd QC. Boyd QC was a half-hour television programme starring Neil Denison, no relation to... Michael Denison, no relation to Neil Denison, the common sergeant.
Yes.
As a rather sophisticated, urbane silk. And the whole idea of presenting a case and arguing a case struck me as a very interesting way of earning a living. And it was, because being at the bar, it's true the cause comes first and then the arguments later, but you are dealing with real people who are involved with real problems. And in crime, more than often than not, in circumstances where they barely understand what is going on.
And it was crime you wanted to do?
I wanted to do a mixed practice, and I did a mixed practice. So I suppose half my time I spent doing crime, but I did a lot of personal injury work, initially for claimants or plaintiffs as they were then called, but latterly for insurance companies. I initially started defending crime, but latterly was sent more and more prosecutions. That's the way it sometimes works.
Yes.
So I tried a mixed practice, and that's what I did for between 1971, when I finished pupillage, and 1986, when I took silk.
Well, you were obviously pretty well known to get this brief. I mean, they wouldn't have picked you otherwise had you not had a good reputation. So when you were given it, did you think you were up against it? I mean, here, the Fred West, thought to be the main protagonist probably at that time. He'd admitted the killings. How much of a challenge was it?
Well, the case was circumstantial. As I said to the jury, and it's funny, I can still remember, nobody said they saw Rose stab, or nobody said that Rose admitted it to them. So there's no direct evidence, but there was a circumstantial case. And the circumstantial case rested on the fact that there were 9 bodies buried under the cellar and patio and bathroom of 25 Cromwell Street. And that circumstantial case was certainly rebuttable, but it wasn't trivial.
Because she, of course, protested her innocence.
From first to last, she said she had absolutely nothing to do with it. That led to what, for me, was a telling part of the case, which was the way in which she answered questions. As you're aware, given your experience, cross-examination is really a mechanism whereby the cross-examiner speaks to the fact finder, the jury, through the witness. One of your colleagues in another paper wrote after my cross-examination that it was a pretty poor cross-examination because it was very structured, very prepared. I only asked questions which elicited the answers yes or no, and I never gave her a chance to explain. And I sent this article to the director of the National Institute of Trial Advocacy in the States, who I knew very well. And he said, well, if I wanted to define a great cross-examination, those are the three criteria. You structure it, it's heavily prepared, you only ask questions which have the answer yes or no, and you never give them a chance to explain. So let me give you an example of that in the case of West. So I started the cross-examination by asking her to confirm that she knew nothing about any of these girls, absolutely nothing. I said, well, let's just unpick that. You never saw any of the girls in your little house in Cromwell Street? No. You never saw any of their possessions inside Cromwell Street. They were all buried naked. You never saw any unwanted or unusual female clothes? No. You never saw any blood in the cellar? They were chopped up, these bodies?
Yes.
No. You washed Fred West's clothes? Yes. You never saw any blood on his clothes? No. You never saw him washing his hands in blood in the sink? No. You never heard any noises from the cellar, whether screaming or cutting? No. You never heard anything about any other girl in the house except the lodgers upstairs? No. And you certainly never told anybody anything. So the idea of the three wise monkeys. I saw nothing, I heard nothing, I said nothing. And one of the writers of one of the books subsequently said, well, I made a false point that she must have known, therefore she must be guilty. That wasn't the point that I made at all. That wasn't the syllogism that I used. What I was saying was she must have known that all could not have happened in the cellar of 25 Cromwell Street without her being aware.
So at the very least, she knew and was complicit to that degree.
Well,
However,
but it goes further. So she must have known, yes. Now she could have said, well, I was terrified of Fred that he'd kill me, but she never did. Had she done so, she would have had a whole series of other questions to answer. But she only always ever said she knew nothing. Now, why didn't she say, if she must have known something, well, it was Fred and I was terrified he was going to kill me? After he died, there was absolutely no reason why she shouldn't.
no.
If it was true.
Should she have ever even, because I gather that that was a surprise, that she even went into the witness box?
Well, it's not for me to say whether she should, because she may very well have insisted. Did it do her any good? I think not. Certainly, a journalist who covered the trial, speaking to a friend of mine who was a solicitor, said, well, I listened to the prosecution case and I thought, well, I was pretty sure she'd done it, but could I be sure beyond reasonable doubt? Then I heard her give evidence and I had absolutely no doubt at all.
So her giving evidence clinched it, really?
Well,
probably for the jury. And under your cross-examination?
I can't say that, can I? I don't know how the jury worked it out, but I was surprised she gave evidence. I only had a little notice that she was going to give evidence. Fortunately, it was over a weekend, and because it was half term, my wife was taking my youngest children away, and I stayed that weekend in Winchester. And on the basis that she could be giving evidence, I spent the weekend preparing cross-examination. I can't say that she didn't insist on giving evidence, but I think she made the case, she converted the case from what could we really say from the circumstantial evidence into, do we believe this lady?
How did you find her? Because what kind of a person was she to have committed these crimes? How did you find her?
She was incredibly tough. Don't get me wrong, she had had a pretty rotten life. She'd been abused as a child herself. She clearly got involved in prostitution. She had a sexual proclivity, so the evidence was dangerous. But she came across to me as incredibly tough. And in my judgment only, her distress when giving evidence was in the wrong places. For me.
Can you give an example?
I can't give an example because I can't specifically remember I remember the sensation, feeling. That's odd.
As if she was acting or putting it on?
And so I'll give you an example of an odd answer. So one of the people she was charged with murdering was Fred's daughter, Charmaine. And Charmaine had a little friend who came to visit and saw Charmaine standing on the table with some sort of strap around her arms, being hit with a wooden spoon. And I was putting that to Rose West, and she said, we were very poor, we couldn't even afford a wooden spoon. And there were lots of little things like that. Why did I argue that she was the one that killed Charmaine, which I did argue? That's itself quite an interesting story. One of the remarkable features of the case was that we found these 10 bodies. One of them was actually Heather West, but they were skulls, they were skeletons, they weren't fully fleshed. How were we going to identify them? And this was the work of a professor of forensic odontology called David Whitaker. And what he did was he took the skull and he photographed it in the same picture, in the same position as a photograph of somebody who he thought might have been one of the victims. And he was able to match up the teeth and the skull with the remains. And the result was that, with one exception, from the beginning, 9 of the victims, their identity was not challenged. The evidence was so compelling.
That's incredible.
The rather difficult problem, a little bit more on this, was Charmaine, because we didn't have a decent photograph of Charmaine as a child. And during the course of the investigation, I think it was one of the nationals bought a photograph from a school photographer. And the school photographer had gone round and taken pictures of every single child.
Yes.
And there was a smiley photograph of Charmaine.
Ah, right.
And therefore Whitaker was able to compare the skull and that photograph. But it's much, much more than identifying Charmaine.
Yes.
Because Charmaine was, I think, 8.
Yes.
Teeth were erupting.
Yes.
Were falling out. And he could match the growth of the new teeth with the photograph.
Incredible.
To such extent that he concluded that Charmaine had died within a specific period of the photograph being taken. And we knew exactly when the photograph had been taken.
That's incredible. And it was important, wasn't it? Because she was the one. Fred West was away at that time in custody, I believe, wasn't he?
You're absolutely right. Well
so
done.
This was the critical one that would have pinned it on
Yes.
Rosemary.
There wasn't a complete overlap. There was 2 weeks that he'd been released that it could have been him.
Oh.
But there were the 2 months when it couldn't.
Right.
And we had this evidence of her hitting Charmaine. And we also had a letter that Rose had written to Fred saying that she was having difficulty controlling Charmaine, who liked it rough. That was the phrase in the letter. So I'm not suggesting that Rose buried Charmaine in the flat in Midland Road, but I argue the jury could legitimately infer that she'd been the one that had killed her.
Exactly. I mean, it's absolutely horrific. And I think you said in opening, the discoveries were more terrible than words can express. So when you think
You're absolutely right.
When you think back on the evidence, which we don't need to go into the whole horrific detail of it, but how did you find coping with having to read and digest all this stuff and keep it in your mind?
It wasn't easy, and I was very conscious, and I was told that those who'd been involved in the Moores murders never spoke about it, but it affected them, and I was advised to be prepared to speak about it.
Really?
So
as a way of dealing with it.
As a way of dealing with it, and so occasionally, not often, but just occasionally, I have. And if somebody asks me a question, I'll answer it.
And what was really, if you can identify a single fact, what was the most shocking aspect of it, would you say, if there is one? Or was it the whole combination of circumstances?
Well, it's a combination of circumstances, but the obvious sexual abuse of these girls who were found in more than one case with bindings around them, around their heads. One of them had an air tube in their mouth. Really horrific stuff. It's undeniably the case that it lives with me. And there is only one other murder that I prosecuted that lives with me in the same way.
And which was that?
It's a case that has continued over the years. It's the murder of a woman called Helen McCourt in Liverpool. The defendant, Ian Sims. The body was never found, and to this day hasn't been found. And Mary McCourt, I think, still looks for the body. This was a killing in 1988. And I was prosecuted in March 1989. And she certainly looked at the body and was very keen that Ian Sims should not be released without saying where the body was. In the end, he was released after he'd served, I think, something like 31 years in prison. He died of cancer within the year. But Mary McCourt obtained what is called Helen's Law,
Oh, yes.
which requires the parole board to have regard to the fact that the body hasn't been recovered. I actually believe the parole board always did have regard to that fact anyway, but
now it's in law. Yes.
So that's another one.
So it comes to the trial itself, and you've mentioned the difficulty that there's the evidence against Rose West, who you were prosecuting, was circumstantial. What other difficulties did you have in the trial itself? Were there others? And were there turning points in the trial where you thought this is not going well, or conversely, this is going well?
How much time have you got for stories? So, one of the witnesses was a lady called Caroline Evans, who was a teenager, had been hitching from her boyfriends and had been picked up by the Wests, who I think, as a couple, picked up young women who felt comfortable going into a car with a woman. And Caroline Evans was persuaded to come back and be a nanny for Fred and Rose and their little children. But she was assaulted, undeniably indecently assaulted, and the subject of physical injury while she was there. And as a result, she left. She actually went back once, but after she'd been assaulted, she reported the matter to the police, and Fred and Rose were both prosecuted. And they pleaded guilty to indecent assault and assault occasioning actual bodily harm, for which they were both fined. We're talking about the very early 1970s. And her evidence was very important because she had Fred and Rose acting together, both of them assaulting her, both of them treating her with violence. But after all this came out and they found bodies in Cromwell Street, she was offered and was paid money by the press.
This all came out, of course, at trial, didn't it?
All came out at trial.
Which I suppose discredited a lot of the witnesses.
Well, that was always the challenge, and it'll lead to another challenge, which I can mention in a moment. So I arranged for the police to investigate every single witness, and I wanted to know about everybody who'd been paid any money by the press, and lots of them had. And I don't blame them. These were people who did not have very much, and so an offer of money by the press would be
life-changing, perhaps, or
perhaps
at least
not life-changing,
significant.
at least significant. And she'd been paid money, and I let it out in chief so that it was out there. But not surprisingly, Dick Ferguson, who was leading for Rosemary, cross-examined them all about receiving money, and argued that they were exaggerating and providing an account which was more to do with how much money they were receiving than the truth.
Sure. Well, that must have been quite a depressing moment for you when it came to light.
That happened all the time, throughout the trial.
And did you think you really had an uphill task after that?
It was a problem because, I remember saying to the jury in terms, what are these people to do who are living in the bottom rungs of society when they're offered money? But in relation to Caroline Evans, I remember preparing a re-examination after she'd been cross-examined. And the question I asked her was something like, is money anything to do with why you are giving evidence in court? And I knew that would upset her, and she burst into tears. And she said, no, she just wanted justice for the girls that didn't make it.
Oh, yes.
And I was conscious this was likely to be a reaction, but that's the job. You want the jury to understand where this lady, this witness, is coming from.
Yeah.
And she later wrote a book saying that she'd been very pleased that she'd stood up to me and then stood up to cross-examination. But then she was very upset when I, who was supposed to be on her side, asked her a question which broke her up. And she did actually say that to me when I met her at the end of the trial. And I said, well, I explained why.
Yes.
And she then understood.
Why you did it, exactly.
Why
you
I
had
did
to.
it. But that's the job.
That's right. And then tell us about, you had another blow with a witness, I believe, called Janet Leach.
Now,
the
Janet
appropriate
Leach,
adult who was assisting
Fred. So now, this requires a bit of explanation. Because the police were determined that Fred should not be able to say that he was suffering from mental abnormality, they arranged for an appropriate adult to be present with him. An appropriate adult is usually a social worker, but they had difficulty with him and social workers because his kids were in care and therefore may have been conflicted. So they went to Janet Leach, who I think had been trained, but I'm not sure she'd ever
practiced.
And she was present at all the interviews of Fred. And when Fred committed suicide, she made statements to the police. Fred had given many, many interviews, admitting, as you said earlier, that he had been involved in killing these girls, but denying that Rose had had anything to do with it. But to Janet Leach, he said that she'd been up to her eyes in it, effectively. He did say to the police he was protecting somebody, but never said who.
Right.
But to Janet Leach, he made it clear that it was Rose.
It was his wife, yes.
And of course, that's not evidence, and would never be evidence against Rose, because it's hearsay.
Quite, yes.
And Fred wasn't there to give evidence. So the police got these statements after Fred had died, but there was no chance of using them. They would never be evidentially valuable, except if the defence relied on Fred's assertions that she wasn't involved, then I could call Janet Leach to rebut the credibility of Fred.
Oh, excellent. So you could use it to your advantage then.
To undermine Fred. It wasn't evidence against Rose, but it undermined Fred. Now, it never occurred to me they would rely on Fred's interviews for that very reason, because Fred had also made admissions to a probation officer and to a doctor.
But they did.
And they relied on a number of Fred's interviews and assertions that Rose had nothing to do with it. The reason I thought it was odd was that Mrs. West her case was that Fred was a multiple murderer. So how could they put him forward as a witness of truth in relation to Rose? But they did. Now,
well, was that a bit of luck for you?
Well, I think it was pretty lucky for me. It surprised me. Again, it may very well have been Mrs. West's choice because the barristers would ultimately take instructions. It was her case. I was surprised because I then called evidence in rebuttal. And the evidence I called in rebuttal took 4 forms. Sorry, this is a long run up to Janet Leach. The first form was to rely on what they said, what Fred had said, about a girl called Lucy Partington, who was studying medieval English at Exeter University, had just converted to Catholicism, and I was learning the lute, I remember that. And she went missing, and there was an enormous search for her at the time. She'd been visiting a paraplegic friend and was going to get the last bus home, clutching her application for Goldsmiths to do a postgraduate degree. Never seen again, until her remains were found in Cromwell Street. And
Awful.
Fred, his story was he'd met Lucy in a park in Cheltenham, they'd had an affair, she'd complained she was pregnant, and she was going to tell Rose, and he'd lost his temper. Well, now that was an obscene lie. And I wanted to demonstrate that it was an obscene lie. I ought to add that I specifically consulted the parents of Lucy. I said, it's my choice. I've got to run this case, but I want you to know what I'm thinking of doing. And if you have an objection, then I want you to tell me. And both of them independently said, no, if that's what you want to do, you do it. And so that was the first limb. The second limb was the probation officer. The third limb was the psychiatrist. And the fourth limb was Janet Leach, the appropriate adult. She had made a statement. She said she'd not made any arrangement with the press. And she was giving evidence. And she gave evidence. And we got to a lunchtime on, I think, Thursday. And Dick Ferguson had cross-examined her a bit, and the judge, Mr. Justice Mantell, said, well, I'll sit late to let you finish her, because that was going to be the end of the evidence. And Ferguson said, no, I'm going to be another hour or so, so we had the break. In that break, in the lunch adjournment, she collapsed.
Physically?
Physically, and was taken to hospital. And we thought she'd had a stroke. So we adjourned it to the following day. That night, I received an email, or fax it was in those days, from David Eadie, then a Silk who was acting for one of the newspapers, with a copy of the contract that Janet Leach had made with that newspaper, receiving a very substantial sum of money for telling her story.
So she'd completely lied about
I'm
not receiving
afraid she
payment.
had not told the truth. Yes, in other words,
Well,
yes.
that must have been something of a blow.
That was certainly very disruptive. Ferguson said to Mantell, it was critical, we've got to discharge the jury and start again. We'd never have been able to do this trial again.
No, you were right at the end of it at this point.
We were right at the end of it. And I was saying, well, look, forget her evidence, I'll abandon it, and I'll make it clear that she's not told the truth and can't be like, it's not good enough, said Ferguson. So Mantell decided that we would wait and see whether she was good enough to come back to
This was the judge,
evidence.
Mr. Justice Mantell.
And we waited a week for her. And after a week, she came back from Hallamshire, the Royal Hallamshire Hospital, with a doctor. She was wheeled into court in a wheelchair with a doctor standing behind her. And she then confessed that she'd had the payment. And her evidence was over quite quickly.
But was it still of value or not really?
Well,
now
I didn't really rely on it because she confessed the lie.
Yeah.
But it meant the trial was back on course.
Yes, which was the main thing.
Which was the main thing.
Yes.
So that's Mrs. Leach.
When the jury went out, I mean, I think you've said before, and people have commented to say, it certainly wasn't a foregone conclusion, was it? What did you feel? Did you think that the jury would come back with guilty verdicts?
As I'm sure you appreciate, barristers get to know one another very well during trials of this nature. And I'd done a previous trial with Dick Ferguson. I knew him very well. And we were walking up and down And he said to me, Brian, the difference between us is that you can't win this case and I can't lose it. And I'll tell you why I mean that. We both know this case is not overwhelming. If she's convicted, the world will say, well, of course she was guilty. What job did he do? And they'll say of Ferguson, well, he didn't have a chance.
Yes.
And if she's acquitted, they'll say, what a brilliant defence, and what idiot did they get to prosecute him? And we both know this is far from certain. And it was far from certain. The Court of Appeal later said it was overwhelming. All right. I didn't consider it overwhelming when first I read it.
No.
There was a case.
Yeah.
But it...
And by the end of it, when the jury retired, did you feel reasonably confident, or could you really genuinely not say?
I felt the jury were more likely to convict than not. So they went out on day one and came back mid-morning of day two, I think. And they then convicted, very interestingly, of the murder of Charmaine, the very first, and the murder of the daughter, Heather, the very last. Oh. And the reason that they were relevant was because, of course, Charmaine, the odds are Fred was in prison. And in relation to Heather, there is no doubt that Rose had lied about having spoken to Heather after she was dead.
Right.
So
they were critical once they did those two.
So those two,
yes.
They did.
Yes.
They then went out again and then came back at the end of that day and convicted of one more murder. They convicted of the murder of Shirley Robinson, who was pregnant by Fred at the time. But they left out then the 7 similar fact cases, which depended upon an assessment of similar fact evidence. And they went out the following morning and then asked a question of the judge, which he answered, not in the way that Ferguson wanted him to answer it, and that was a subject of appeal later, which got nowhere. And then they came back and convicted of the other 7 murders.
Well, that must have given you some satisfaction for the sake of all those poor women. And what a burden. Did you feel the burden and the responsibility of doing justice for them?
There is no question about that at all. And the very fact I can talk about it now, even perhaps at tedious length, is that it still lives with me today.
I'm sure it must do. Finally, on this case, do you have any view as to who was the more culpable between them, between Fred and Rose West, or were they mutually responsible, would you say? I mean, what's your view of that?
It's quite difficult. It has been said by people that Rose was the sexually deviant one Fred liked to watch, and there's no doubt about that because she was a prostitute in her own home and he had a hole through the wall and he could watch. But I'm not able to say. If anything, I think they potentiated each other. But I wasn't there. I can't tell you. I have never been concerned that she wasn't fully involved.
As we said, this was over 30 years ago. Things have changed a lot in the Crown Court. And as we know, you've just conducted a review of how things are in the Crown Court, which is not very good at the moment, with huge backlogs of cases. First of all, can I just ask you, how different are things now? I mean, obviously you're not a prosecutor, you've risen to the top of the judicial system and been one of the most senior judges. But have things changed in the way cases are run and trials operate?
Enormously. And they are in part, the changes are in part involved in creating the very serious situation that the justice system is in today. So let me explain. When I started the bar in 1970, there were the judges' rules, and the judges and police officers would make notes in their notebook hours later. Do you remember all that?
Yes, of course I do. Before the Police and Criminal Evidence Act.
Absolutely.
Yes.
And they said, well, I made the notes as soon as I reasonably could. 3 hours later, and it's word for word perfect.
Yes.
So there was no disclosure of unused material in 1971. Later, the Attorney General's guidelines required the police to identify names and addresses of witnesses from whom they had taken statements, unless they were alibi witnesses, when they didn't even have to disclose that.
Yes. Astonishing when you look back on it, isn't it?
Absolutely. So our protections have increased immeasurably. PACE, disclosure of unused material.
PACE being the Police and Criminal
the Police and
Evidence
Criminal
Act.
Evidence Act, correct. Disclosure of unused material. Special measures for victims. Intermediaries for those who are neurodiverse. Increase in the number of people who do not speak English as a first language, so require translators.
Are all these good changes, or has it gone too far?
Well, they're all intended to improve the fairness of the trial, but the consequence is that they have increased the length of trials. I've not finished. Add to that bad character and hearsay evidence now admissible.
Yes.
The different caution about not saying, if you later rely on in court, there's now potential adverse inference. On top of all that, CD, communications data. A mobile phone didn't exist in 1970.
No.
But now, most prosecutions rely on communications data. That's the metadata of phone calls. Who called whom, when, through which cell site did it pass? Data generally. The data on your mobile phone would go up to the top of Everest, yet somebody has to look at it, particularly if it's relevant, and you only have to look at what's happened to rape trials and the allegation of digital strip searches, because the police are required to check what a victim and a defendant has said to the various people they may have communicated with, consistent with the allegations that are made.
So is it now making it almost impossible?
Not impossible,
to run the system?
But it's very difficult.
Yeah.
I've not quite finished.
No, go on.
You've also got CCTV and body-worn cameras, all of which generate more and more evidence. Live links for witnesses. All this takes longer and longer and longer to try. So I could do 2 trials in a day in 1970. Now no trial takes less than a day and a half, 2 days. Very few of them. So all that has added enormously to the pressure on the Crown Court. On top of that, crime has become more complicated. There were rapes when I started, but nothing like the number that are now reported. When I started...
That's not an incidence of the crime. You're saying that's a report, an element of the fact is more reporting goes on.
More reporting, but also when I started, there had to be corroboration. Now there doesn't have to be corroboration.
Right.
So there are legal changes that have affected. Historic abuse has mushroomed. So taking a vehicle without consent, much less. Cybercrime and fraud is the daddy that is going to overwhelm us all in crime.
Gosh.
And yet is difficult to investigate, difficult to prosecute, and time-consuming, even if it is all justiciable in this country. Because if frauds are occurring from abroad, they may not be justiciable, or you can't get hold of defendants. So all those add to the enormous pressure on the system. On top of that, add in the fact that sentences have got longer and longer and longer. When the Strangeways riot took place, there were 40-odd thousand people in prison, which Lord Woolf then said were too many. Now there are over 80,000 people in prison.
Double. And heading up to 100,000 in not too many years, perhaps, if something isn't done.
Provided you've got places for them. There aren't places. So the result of that is that the 14,000 plus remand prisoners, those who are remanded in custody awaiting trial, are not necessarily in prisons local to their courts. So there is much complaint about delays in prisoner escort services and courts waiting for hours. But if the defendant is lodged in a court that's 2 hours away, and they've got to visit other courts as well, to expect everything to be able to start 10:30 is unrealistic.
So this is why, in your opinion, we need, and you've said in your report, we need radical change.
I've said we needed more money, we need radical reform, structural reform, and we need greater efficiency. That's what I said.
As a package, which the government has accepted.
The government has presently accepted it.
There's been a lot of opposition to your proposals, in particular to radically restrict trial by jury, not least from the bar. Do you think that's likely to go ahead?
I can't say. I simply don't know. My response to the question is, this is no longer my problem. I have done my best. People have said, oh, it's not the fault of juries. Of course it's not the fault of juries. I've never for one moment suggested that juries were to blame for what has happened. I am a great believer in jury trials and have indeed spent 50-odd years arguing in front of and trying cases with juries. So I believe that the public recognise and accept jury verdicts, even though there aren't reasoned decisions, which is something of an issue. But we can't carry on as we are. Now, I understand the opposition to the bench division, which I suggested.
That would be a judge sitting either alone or with two people.
Correct, or with two
magistrates.
Two magistrates. And I understand the bar don't like it. But if not this, then what?
Exactly, yes.
You can't just say, we're not going to do this, that, the other, and then expect the system to be able to cope. Because you can't sit enough days, there aren't enough courts, judges, or indeed lawyers to staff the sort of numbers of days that you would have to sit.
Do you think the case is as compelling as it was when you reported, because people point to the fall in the backlog numbers?
The backlog, it's true, has fallen, I think, by 87 cases. So it's not gone up. I accept that. I think there are fewer charges at the bottom end. So whereas there used to be many charges of assault of an emergency worker, which was capable of being elected for trial, they're now being charged as common assault. I think that some courts have been set up as blitz courts to deal with these assault of emergency workers, these small cases. My problem is, what is it doing to the backlog of cases in weeks, not in numbers, but the number of weeks trial there are remaining outstanding?
Because that is more significant, really, isn't it? How long people have to wait, not how many are waiting.
Well, it's not just by the weeks. I mean, how long a trial is. Quite apart from the issue of delay, and they're listing trials into 2029, 2030. Well, I believe that's a denial of justice.
So if they don't proceed with these reforms, let's just say, for example, they don't, what do you think will happen?
I think the system will get slower and slower and slower. And
grind to a halt, and as you say,
well,
injustices.
There's no doubt injustices, because one of the issues presently is that victims are withdrawing. And a story I told at a recent debate was that in the 1970s, I remember acting for somebody, more than once, towards the end of the year, and I would say, look, this is a very strong case, and if you're guilty, you're far better admitting it than pleading guilty. And more than once, somebody said to me, a defendant said to me, well, Mr. Leveson, I am guilty, and I will plead guilty, but I want to spend Christmas with my kids. So how much more, if you want to manipulate the system, I want to spend Christmas 2028 with my kids, which is what they, and what's not to like? A victim may withdraw, the witnesses may forget. Now, I'm not suggesting that that's every defendant, but there are defendants who are trying to game the system.
And increasing in number, presumably.
I anticipate so. There are defendants who are equally as affected by the delay as victims. So I heard a story of an undergraduate who was accused of rape while studying at university, long since finished his degree, couldn't get a job because he had to tell potential employers that he was waiting trial for rape. So this isn't a one-side thing, but there's no doubt that one needs to change the culture of those who are charged with crime. When I started, defendants pleaded guilty on maybe the first or second occasion they were in court. Now, lots of them are only pleading guilty on the fifth or sixth occasion. And every time they come back, that's more time, more expense, and creating more delay. So
you paint a very bleak picture.
There's 1,300 pages of it if you want to read it. I am.
Do you feel you will have wasted your time if it's not enacted?
No, because I've told it as I believe it to be. It is for others to decide. I watch from the sides. I am no longer a judge. I'm now beyond the age in which I could ever sit as a judge, although I didn't sit after I retired in 2019. So it is for others to decide. All I can say is I've done my best. And I'll give you one other illustration of the point I'm making. In 2024, 1,100 cases were ineffective. In other words, they got to court but couldn't be tried. Not because there wasn't a judge or a jury or a court or the witnesses or a defendant, but because either there wasn't a prosecutor or a defence barrister or advocate. So we need more people entering the criminal profession, criminal justice profession. More barristers and more solicitors. And
why are they not?
Well,
it's money partly, isn't it?
It's money partly.
And the conditions they have to work under?
They are. You've read the report, clearly. On top of that, if you read the report, you will see the criminal defence solicitors are getting older, and the younger people are not coming into that aspect of the profession.
No.
And we need there are advice deserts in the country. We need more criminal solicitors, more criminal barristers. And the one part of the report that the professions liked was my asserting that and encouraging a re-evaluation of fees.
Yes, of course, they would. Well, very last question then, just coming back to the horrendous trial of Rose West. Did it, at the end of it all, did it change your view of human nature? Did it surprise you in any fundamental, radical way?
It hasn't changed my view of human nature, because in the 28 years that I practiced the bar, I saw many, many cases of horrific human behaviour to other humans. But I equally saw many cases that showed unbelievable human kindness. And it's right that I provide that balance. So I did a lot of personal injury work, including acting for the parents of cerebral palsy babies who've been birth damaged. And it was humbling how parents, sometimes who had struggled with other challenges in life, came together to look after their incredibly disabled child. And it showed human nature at a different level. So one of the great pluses of practicing law, and if this is for the University of Law, I'm pleased to say it, is that no 2 days are the same, no two people are the same, no two cases are the same. Every case relies on different human problems approached by different people in different ways.
So it's still a worthwhile
Not
job.
only worthwhile, but truly fascinating. And I would not have missed it for anything.
Fred West died on January the 1st, 1995. Rose West was convicted in November 1995 of 10 murders, although it is believed that she and her husband were responsible for many more killings. Rose West is serving a whole life sentence. She has always maintained her innocence. Sir Brian Leveson is now retired as a judge. He is currently the Investigatory Powers Commissioner, overseeing the use of surveillance powers by the UK public authorities, including the intelligence agencies, police and other bodies. He was appointed for a third term last October. He was made a life peer in the Political Honours List in July 2026 and will take up his seat in the House of Lords later this year. This episode is dedicated to the memory of the known victims of Fred and Rose West: Anne McFall, Rena Costello, Charmaine West, Linda Goff, Lucy Partington, Carol Cooper, Juanita Mott, Shirley Hubbard, Therese Siegenthaler, Alison Chambers, Shirley Robinson, Heather West. This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.